Anybody hear me?
Yes.
Can anybody hear me?
Yes, we can.
Thank you.
Hey, Jesse, this is Joe from Generator. So I have your slides pulled up. We can transfer the presenter to you if you want to present that on your own computer, but as a backup, we've got it on our side too.
Okay, so sorry, I'm new to Zoom, like probably many people are right now. So would it be best for me to just rely on you to move the slides, or do you want to?
Yeah, that's no problem. If you just want to say next slide, and
I'll also transfer control to him, Joe. So we can, if you see the remote control setting, I think that will grant him access. Is that on your end?
I might not have that if I'm just a panelist. Let me see. It does not look like I have that.
Let's see. Trying to figure out where I saw that last time. I think. Oh, okay. Maybe Jesse, it's on your end, I think. So where it says you are viewing Joe Baz's screen, do you see that?
Yes, I do.
So if you click view options, it'll say request remote control. And then I think he can grant you that. And then you will be able to click through from his screen. And if that gets too complicated, we can do it the other way as well.
Yep, and so I've got your presentation right here, actually.
Okay, and then is there a way that, I think Sarah might be having trouble actually speaking. Is there a way she can dial in?
There, she should be, it should work now.
And Jesse, do you want to give just a quick test? Are you able to flip through the slides okay?
Yes, it looks like it. And then, okay, yeah, forwards and backwards.
There we go. So Sarah is now a panelist, so she should be able to speak.
Okay, I'm separately chatting with her, and it looks like she just got kicked out.
Yeah, she's now back in though as a panelist.
Okay.
Okay, this is Sarah. Can you hear me?
Hi. Yep.
Yes.
Yeah. Is there a way for me to use phone audio? Usually Zoom gives you a dial-in number also.
Yes. Let me pull that up.
Wait, I just found it.
Oh, okay. And then did you all say you'll be monitoring the Q&A on your end?
I think that would probably work best because we can kind of try to group questions together too.
All right, great.
Sounds good. And Lauren, whenever you're ready, unfortunately, I can't show my screen and control the participants. So if you want to let everyone in, I can give an introduction.
I think everyone's in.
Oh, okay, perfect. So we'll get started then. So welcome everyone. Thank you so much for attending our daily webinars for our Wisconsin Emergency Response Program. We're really excited to have two special guest speakers today. We're going to be joined by both Jesse Dill and Sarah Platt. So they have a really great presentation, and I'm going to just turn things over to them so we can get started. And we will have a Q&A at the end of this. So if you notice on your Zoom, there's a place to type your Q&A questions. So please type those questions in there as they come up, and we will address them at the end of the presentation. So Jesse and Sarah, I'll give you the floor.
Okay, thank you, Joe. Good morning, everybody, and welcome to today's webinar on COVID-19 and employment law issues for the Wisconsin business. My name is Jesse Dill, and joining me today is my colleague, Sarah Platt. We're both attorneys in the Milwaukee office of Ogletree Deakins. And for those of you who aren't...
Hi, everybody.
Sorry, Sarah.
Just Sarah chiming in, making sure my audio works.
For those of you who aren't already familiar, Ogletree Deakins is a national labor employment law management side firm. Sarah and I have been both very busy lately helping to counsel employers through the myriad of issues related to COVID-19 and the fast and furious pace of new laws that have been passed in response to it. We're I do with the latest explanation of the employment laws that are likely going to affect you in the coming days, weeks, and months if they haven't already. And one of the advantages of coming from a national firm like ours is that we have a pool of resources and particularized knowledge we're able to provide from our group of 900 attorneys nationwide and internationally. I'll remind everybody at the end of our presentation, but I really highly encourage you to visit our website. And that's because we're pumping out an impressive amount of free content to try and help employers with the issues as they arise. And you'll find some days 4 or 5 blog posts, a lot of frequently asked questions, just a whole lot of resources that you can quickly turn to navigate some of the common issues that we're addressing on a day-to-day basis. So while we're going to touch on some of the questions we're receiving and that we may think will come up in your workplace, there's sort of a word of caution that comes with this presentation. We're going to update you on the recent developments, and we ask that you keep in mind the law in this area is constantly changing, literally on a hour-to-hour, sometimes minute-to-minute basis. For example, since the Family's First Coronavirus Response Act was passed, the Federal Department of Labor has come out with 3 unannounced updates to their guidance that has answered a long list of questions. While we're thankful for that,
and then changed those answers.
Yeah,
and then changed those answers within their own FAQs. So it's constantly changing.
Right. So while we're thankful for the guidance when we can receive it, unless it changes, it is sometimes changed, as Sarah said, sort of our prevailing interpretation of these laws. And we're constantly having discussions with our colleagues across the country, and there's in some of these issues, there's a rigorous amount of debate as to how to properly interpret and apply these laws. So just keep in mind, much of what we're going to be covering really has no or little guidance in a lot of respects. And so we're working based on our knowledge, experience of how a lot of these laws function or are likely to function. But it might not always be consistent with how courts and government agencies ultimately apply or even interpret them on a day-to-day basis. So we're going to cover a few significant points here today. One is we're going to update everybody on the Wisconsin and Milwaukee stay-at-home orders. 2, we're going to cover some basic safety issues. 3, we're going to talk about the latest federal legislation, the CARES Act, and primarily the unemployment changes that are implemented by, or that will soon be implemented as a result of that legislation. And then Sarah is going to do the heavy lifting on the issue that I'm sure many of you will have questions about, the Families First coronavirus response and the emergency paid sick leave, and then the extended family medical leave benefits that have come about as a result of that. You know, we're going to be covering a lot of the latest and most impactful changes, but we're also covering topics that, as long as you're an employer with less than 500 employees, our content is going to potentially apply to you. This is really a broad subject matter that we're going to cover for employers. Okay, so let's begin with the Wisconsin Safer at Home Executive Order and then the Milwaukee Stay at Home City Order. These are our local efforts to flatten the curve of COVID-19 infections. And what each order does is identifies essential activities and businesses which are permitted to remain open as long as they practice social distancing. And then everything else is considered non-essential and prohibited. Under these orders, companies are to self-assess which category they fall into. That is, whether they are an essential business or whether they are a non-essential business. You're not going to have to obtain government approval to stay open as an essential business for now. Really, the presentations I've attended by our local government officials are discouraging any sort of expectation that that's going to happen in the future. But even if your business is non-essential, it can continue in 2 key ways. One is through teleworking. The orders are permitting everybody to telework and encouraging it. And then the other is that each law or each order allows employers to perform what are called minimum basic operations. And that's to do things like processing payroll and employee benefits. Even if you're non-essential, you can carry out those functions. Now, whenever we have 2 laws that potentially apply to any business, the question comes up, which of these do I have to follow? If you're in the jurisdiction of Milwaukee, you're going to want to follow the one that offers the most strictest regulation. And in many, many ways, these laws overlap, and that shouldn't be an issue. But there are a couple of key differences that I tell employers to keep in mind when addressing these laws. One is that under the Wisconsin law, you can apply to be considered an essential business if you don't under the defined categories of essential business. And you do that by filling out a very basic form that's available on the website for the Wisconsin Economic Development Corporation. And basically the extent of the form is to make your case as to why you feel you should be considered an essential business. The Wisconsin Economic Development Corporation is taking these applications as they come in and evaluating them. And their main goal is to see if they can develop some buckets where they believe that there's a group of employers that are making a good and consistent case as to why they should be considered essential. And then the executive order may be updated to accommodate some of these additional essential businesses if the Wisconsin governor feels that they should be updated. The other big difference between these 2 orders is that the Wisconsin order actually provides an end date of April 24th, while the Milwaukee order does not provide an end date at this time. Now, the April 24th date was one that was set by the Department of Health Services, and the Secretary of Wisconsin Economic Development Corp has advised that business or that date might change. It might end sooner. I think it's probably more likely to be extended, if anything. But for now, we have an end date in sight, whereas with the Milwaukee order, it's going to require Mayor Barrett to take some action to end that order. As far as enforcement, both orders refer to the Wisconsin statute 252.25, which provides that any local law enforcement can enforce these up to a $500 fine or 30 days in jail. And for the most part, we're not really seeing a whole lot of enforcement activity. I know there's been some reports of local law enforcement looking to address repeat offenders, but we haven't seen or heard of any businesses being asked to actually stop activity as a result of these orders. But certainly if you hear or experience of anything, we'd be interested in hearing from you after today's webinar. So a few considerations in terms of communicating with employees about these orders. I think it is important to identify to employees, if you haven't already, whether you believe you fall under the essential business or the non-essential business designation, but nothing is required at this point in time. We are getting a lot of requests to help put together some notice to employees and also to provide employees who are going to continue working with a physical presence in a workplace somewhere with something that they can provide to law enforcement if they are ever stopped and questioned about why they are out. But this is mostly, we see it as a peace of mind offering to employees, and it's not something that's required. If somebody is stopped, there is not a requirement to actually present any sort of paperwork or documentation to support the reason for being out. It's just something that an employer can provide to make employees feel a little bit better about the circumstances. Okay, so now if you are going to be operating in full or in part, it's important to comply with safety requirements, and these mostly come under federal law, the law called the Occupational Safety and Health Act. What I have up here on this slide is language from the OSHA statute, and this specific provision is the general duty clause. And it's essentially what requires employers to not subject employees to a work environment that is likely to cause harm. OSHA sets a lot of very specific regulations that probably would not apply to most of the people listening to this webinar, but this is sort of their one catch-all provision to address known hazards in the workplace. OSHA has not clearly defined COVID-19 as a known hazard yet, but there is ample guidance from the CDC about the dangers of COVID-19 and the precautions that businesses should be taking through social distancing in particular. So with all of this warning and recognition, it's probably a very high liability risk under OSHA to allow somebody to continue to work after they've been with COVID-19. And then from there on the list of possibilities, we're really just considering a spectrum of potential risk. At this point, our best practice recommendation is that if you are an essential business or even a non-essential business that's continuing those minimum basic operations, remove anybody who has disclosed that they've been diagnosed with COVID-19, and then from there give high consideration depending on the level of exposure that the individual has had to somebody. If you receive information of a close association with somebody who's been diagnosed with COVID-19. So on the flip side, for many of you, I'm sure you're implementing some remote work arrangements for individuals to continue working, but to do so from their home. Even if you've already coordinated teleworking accommodations, it's never too late to review what's in place and improve on any emergency steps that you had to take to address immediate concerns as recently as yesterday. So with any remote work arrangements, there are some important issues to consider. One is who's providing the equipment needed to perform. And a common question that comes up is, from an employer's perspective, is do I have to actually pay for the equipment needed to perform? Well, strictly the answer is no. In Wisconsin, there is not a law that requires employers to actually reimburse employees costs working from home, even things like cell phone bills and internet bills. There's not a strict requirement in Wisconsin. There are some other states where there is a requirement for employers to actually pay for the costs for some of these expenses. Not here in Wisconsin. One thing you do want to make sure that you're monitoring is if you have any employees who are actually going to be teleworking, but they are making an hourly wage that's close to the minimum wage. There is an argument that those costs of remote working that the employee incurs could actually drop the individual below minimum wage, and they might have a claim under the Fair Labor Standards Act. But generally in Wisconsin, that's not a concern like it is in other states. My biggest concern for employers when they have hourly employees performing work remotely is that they have a good timekeeping policy in place. I would not recommend that employers just sort of send employees home with assignments and not take any precautions to make sure that you have something in place that you can point to as guidance for when employees are supposed to be working and when they're supposed to be not working. So the goal is to avoid claims by employees that they worked, quote, all day and night, and then ultimately are at the end of the work week over 40 hours in time that they have to be compensated for, which means that they would argue that they have a claim to overtime. So if you don't have a policy concerning remote work, I'd say get one in place now. Make sure in that policy you're setting clear hours of work expectations, and that should include not only when an individual should work, but when they should take a break, whether they should respond to emails outside of scheduled hours. If they complete any work, how should they report it? And then also if they feel they've worked more hours than they were paid, how should they report it? And again, the primary concern here is with individuals who are paid on an hourly basis and overtime requirements under the Labor Standards Act, which is the federal law that controls wage and hour requirements, or there are comparable Wisconsin laws too. Keep in mind, we're dealing with a very unique situation. It's okay to set some interim policies to help guide employees and, take those policies back or change them as the circumstances change. Going back to employers that are going to keep their workplaces open for the time being, or even on a partial basis, have individuals coming to the workplace. We've already talked about OSHA and the stay-at-home orders. Well, a key facet of those stay-at-home orders is that they require employers to practice social distancing. And what that means is that you have to have employees avoid close contact of less than 6 feet apart for what's called a prolonged period of time actually means. Also, you have to encourage washing hands with soap and water for 20 seconds as frequently as possible, or using hand sanitizer, coughing appropriately, which is first and foremost into a Kleenex and disposing of it. If not that, into a sleeve or elbow, and definitively not into hands. And then regularly cleaning high-touch surfaces, not shaking hands, and continuing to pay attention to any updates in the CDC guidelines. The reason that this is important that we're seeing in practice is that if you are not strictly adhering to these guidelines, there can be employees who file complaints with OSHA, and then the employer's place of business is potentially going to be in danger of having to shut down if there is somebody who who has a COVID diagnosis and comes into work, and the employer can't identify the strict steps that it took to make sure that there was not close contact for a prolonged period of time between an infected employee and uninfected employee. And it really puts your whole place of employment in danger for having to discontinue operations for a period of around 14 days so that people can be quarantined and recover from any exposure. Okay, so the big questions that I'm spending a lot of my time working on right now relate to the new unemployment benefits that have been included in the Coronavirus Aid, Relief, and Economic Security Act, which is our phase 3 of federal legislation addressing the COVID-19 circumstances. I'm sure, like many employers, many of you in the audience are making decisions of whether to remain open at all or to what extent. And part of this is going to be considering whether you're reducing or reducing headcount. So the effects for employees by those decisions recently became a little bit clearer through this CARES Act. And the CARES Act has a major impact on unemployment insurance benefits. For those of you who aren't familiar with how unemployment insurance works, this is the state-based system required by federal law that acts as a social safety net when employees lose their job. Now, it was never designed to provide full income replacement, but rather be a bridge to help individuals with some income while they looked for new work. Well, that's obviously difficult in circumstances like these where there is mass loss of employment and we're being told to stay inside and not look for new work. So prior to this law, this CARES Act, an eligible claimant could receive in Wisconsin $370 per week. And that was measured over wages the employee received over their last 5 calendar quarters. So what CARES is doing is the federal government is funding some added benefits that states can provide employees so long as they enter into an agreement with the federal government to do so. And the 3 major things that CARES does is first, it establishes a pandemic unemployment assistance fund for previous eligible claimants. And so it's are intended to address people like independent contractors, self-employed, gig workers who are out of work as a result of COVID-19. So it's going to make state unemployment benefits available to those individuals. And then the second big thing that CARES Act does is it provides claimants with a $600 federal funding boost in unemployment compensation. So right now in Wisconsin, or when this goes into effect in Wisconsin, it will mean that a claimant can receive up to $970 in weekly unemployment benefits compensation, which may in fact be more than some people that are receiving benefits actually made while they were working. This was one of the hotly debated items leading up to the passage of CARES, but ultimately the federal government decided to go in the direction of offering more benefits to individuals who are eligible for them. The third major thing that CARES does is it extends state benefits for a period up from 26 weeks to 39 weeks, or another way of putting that is claimants are now eligible or will be eligible for benefits up to 9 months. Now, the $600 federal boost in unemployment compensation, it does have a time limit to it that's only going to last until July 31st of 2020. So these aren't permanent measures that are put in place, but they are temporary benefits that are going to be available to claimants for the short. A common question I get is how, from an employer perspective, is how is this going to affect me? Well, historically, the state unemployment benefits were paid from a fund that was filled by employers who paid taxes on employee wages. And so in the past, you could expect, an employer could expect their tax rate to rise slightly if they had experienced an increase in former employees who are claiming unemployment benefits. Part of CARES, what CARES is doing is it's providing a significant boost to the state unemployment fund that will help finance the mass wave of applications. So we, in part, don't know if tax rates are going to be affected like we would otherwise expect them to be as a result of the loss of employment, because the federal stimulus might actually help make up some of these funds. Okay,
And
so on
Jesse, this is Sarah. I would just note that some states are proactively taking steps to say that claims during this period of time will not impact an employer's rate, their unemployment rate. And to me that, and Wisconsin, I think Jesse, you're more up on this than I am, but I don't think Wisconsin is one of them, which sort of cuts both ways. That may be a sign that people are thinking the CARES Act does not in and of itself do that. So I think that is something to watch.
Yeah, I have not seen Wisconsin issue any sort of guidance or publish any sort of document that would suggest that the tax rate is not going to be affected, but you know, they're updating their publications every day too, and so maybe we'll see something different soon, especially as there's sort of a wave of response that's consistent among the states. So those, what I've described thus far, those are the new benefits under the CARES Act. Those aren't immediately available. We have to wait for the state to actually enter into an agreement with the federal government, but we're expecting that to happen very quickly. And then claimants will be eligible for these new benefits. On the state level, what we've seen is Governor Tony Evers' emergency executive order number 7, which affected unemployment claims in a couple of significant respects. One is that it stopped the work search requirements, so that typically a claimant would have to look for or complete 4 job search actions every week in order to qualify for benefits. That has been temporarily suspended. And then the other part of this, the executive order, was that it made benefits available to someone on quarantine. And part of the pandemic unemployment assistance benefits under the new federal CARES Act is going to expand eligibility for benefits even greater than that. So one common question that we get is if you want to consider placing employees on furlough, are they going to be able to access unemployment benefits? In Wisconsin, the answer is yes. And by furlough, what I'm talking about is reducing an employee down to no hours of work, but keeping them on your employment rolls. And this may be with the intention that you are making your benefits available to employees. So in Wisconsin, like I said, employees are going to be eligible to collect unemployment. But the big caution that I make sure to include in any response to an employer on this topic is to make sure you check with your benefits broker to be certain that your policy would actually allow you to do something like that. Some policies, when the employee isn't actually working, they are no longer eligible for benefits. And this is especially a concern where we're looking at a situation that isn't contained to a single month, but we're probably looking at, well, at this point, at least from the March to April, some benefits are likely at issue with that change of the month. So you want to make sure that you are checking with your broker to make sure that your policy will allow you to continue benefits if somebody's not actually working for you. The risk is that if you don't and your policy does not allow you to continue benefits, you as the employer might become responsible for any medical costs incurred by the employee for the time that they were expecting to continue on benefits, but you couldn't actually provide those through the policy. So if you are considering furloughing or laying off employees, I think the big thing that we're seeing from a lot of employers is that communication is key. Employees want to know for their own morale what is going on as much as you can tell them. And so a lot of employers we're seeing are being pretty transparent in communicating decisions to employees and the effects of those decisions. We have some template notices that we return to regularly throughout the day to help employers communicate these messages. And I would encourage an employer that is putting employees in a position where they're not going to be working any longer, they're going to be working a partial schedule compared to what they typically work to consider applying or to include a reference to unemployment benefits and encouraging them to apply. I would not make representations about whether an individual is going to be eligible or not. That's ultimately a state determination for the Department of Workforce Development to make, but you can certainly lead employees in the direction to apply so that they can potentially be eligible for those benefits.
All right. Should we try to address some of the questions that came in? The overarching question that I saw in the Q&A on that section was relating to how is this going to work for some of the new categories. And unfortunately, that's an area that we don't know yet. And one of the downsides of the bill or of the law is that, I mean, downsides in some ways, is that it is money that's allocated by the federal government, but administered by the states. And so it's going to be different for different states. The state of Wisconsin has not, in my opinion, proven to be super flexible in its processes thus far. You know, they're not great at adjusting their process for new ways of working. And so it'll be interesting to see how they handle these changes for, you know, including the self-employment and other processes that just don't fit in with their, you know, paperwork right now. And so unfortunately, that's a little bit, it remains to be seen. And I think we have to just watch for updates from the state on that. All right, now jumping into some of the new paid leave requirements that go into effect tomorrow. Jesse, are you still advancing the slides? Am I just sorry?
I can do that, yes.
Okay, thank you. Pardon me. So the Families First Coronavirus Response Act, it requires employers with fewer than 500 employees to provide emergency paid sick leave and emergency family leave to certain employees that are impacted by COVID-19. And then it also offers tax credit to offset the cost of those paid leave benefits. It is supposed to be 100% recoverable through the tax credits. And originally the law says that it'll be recovered on quarterly tax payments, but the IRS and Treasury Department are putting out guidance trying to make that recoverable more quickly so that on each payroll deposit, essentially, you can offset the paid sick leave that has been paid thus far. It was interesting that it only applies to employers with fewer than 500 employees. I think the idea is that there would be political and popular pressure on larger employers to provide equivalent leave, but without the government reimbursement. Next slide. Can you jump to the next one there, Jesse?
I am trying, but it's not going.
Maybe I was wondering about, am I frozen or not?
There we go.
Oh, there we go. Thank you. So what does it provide? So the extended FMLA benefit provides 12 weeks of job-protected FMLA leave for employees to care for children if schools or daycare is closed because of the public health emergency. So that's basically all schools in Wisconsin right now. It only applies if the employee is unable to work or telework. So if somebody can work from home with their kids there, they're not eligible for this leave. Employees have to have been employed for at least 30 calendar days. So it throws out all of the other FMLA eligibility requirements that you might be familiar with. So having worked a whole year, having worked 1,250 hours, working at a facility with at least 50 employees in a 75-mile radius, all of those are out the window for this emergency FMLA leave. If the employee has worked for 30 days, they're eligible. The first 10 days of the FMLA leave are unpaid, but as we'll get to in a moment, that's really because they're paid through the emergency paid sick leave provision. So an employee can substitute the emergency paid sick leave, or they can substitute any other paid leave benefit that they have available to them, and it's their choice. An employer cannot require them to substitute or require them to substitute in a particular order. Employees, then after that 10-day period, this becomes a paid leave benefit, which is unlike the existing FMLA benefits, and employees are paid at 2/3 of their regular rate of pay. It is capped at $200 a day and $10,000 in the aggregate, and that is also the cap on the recovery of the tax credit. And so the next one. Then the emergency paid sick leave provision provides paid pardon me, paid sick time to the extent the employee is unable to work again or telework for any of the reasons identified in the law, which is a government ordered quarantine or isolation, a healthcare provider's recommendation to self-quarantine, an employee experiencing COVID-19 symptoms and seeking a medical diagnosis. So those we sort of lump together as issues affecting the employee directly themselves. And then we have leave for an employee who's caring for an individual subject to quarantine or self-quarantine due to symptoms. Interestingly, the law used caring for an individual. The regular FMLA provisions provide for caring for a family member, essentially a parent or a spouse or a son or a daughter. This was drafted more broadly. Or the employee caring for their child who's off school. So again, this is where there's overlap with the emergency FMLA. There's a last category that's sort of a catch-all for the employee experiencing substantially similar conditions as specified by the Secretary of HHS, Treasury, or Labor. I think that's put in there so that they don't have to write new law if we have a different pandemic. And no other conditions have been declared yet to qualify for that provision. All right, so for the paid sick leave benefit, there are no eligibility requirements. All employees, regardless of the length of service, are eligible for this benefit. It provides 2 weeks, but capped at 80 hours of leave for full-time employees. And for part-time employees, it's the equivalent of 2 weeks of pay. The rate of pay is the employee's regular rate for their own issue. So if those 1 through 3 on that previous slide, so a government order, a doctor's quarantine, or symptoms and seeking a diagnosis, they get paid at their regular rate. And so that includes overtime, it includes commissions, everything that would be included in their regular rate under the Fair Labor Standards Act, but capped at $511 per day. For the other reasons, those that are to care for somebody else, the pay is like the FMLA provision, capped at 2/3 of their regular rate of pay and $200 per day. Next slide. So if employers with existing paid leave policies, the emergency paid leave doesn't reduce their rights under state or local paid sick leave laws or an employer's existing laws. And again, you cannot require an employee to use some other type of leave before using this emergency paid sick leave. Now, lots of employers don't want to because this emergency paid sick leave is reimbursable through the tax credit. So many employers would rather employees go ahead and use this. But nothing prohibits an employer from changing their leave programs after the bill is enacted. I haven't really seen many employers doing this. I think in theory, this provision would allow employers to say, we're not going to offer our paid sick leave anymore, and you just get the leave that's available under the federal law, but I have not seen employers doing that. There are a few exemptions. So employers of employees who are healthcare providers or emergency responders may elect to exclude those employees from paid leave. There was a lot of uncertainty about how healthcare provider would be defined and emergency responder would be defined. The DOL issued a response to a frequently asked question this week that defines that very broadly. So that's good news for those types of employers who need their people to come to work to care for patients or residents. The Department of Labor is also empowered to exempt small businesses with less than 50 people if complying would jeopardize the viability of the business as a going concern. The DOL is supposed to provide regulatory guidance on this. They have provided some guidance in the last couple of days through their FAQs that gives us a bit more understanding. Head to the next slide. So a small business is exempt from the mandated leave for the FMLA only if they employ fewer than 50 people and only if the leave is requested because of the child's school or place of care is closed. It is not, the exemption is not available for the 2 weeks of paid sick leave for somebody being under a quarantine order, sick with symptoms, or their doctor recommending a quarantine. You cannot get the exemption from that 2 week period of leave. And what they're asking for is an authorized officer of the business determining that at least one of the 3 conditions described in the FAQ, the DOL FAQ, is satisfied. They're saying don't send any materials to the Department of Labor to seek the exemption. So what they seem to be saying is they're not going to worry about enforcing this emergency FMLA provision on employers under 50, which makes some sense because generally employers under 50 aren't subject to the FMLA at all. And the act already included a provision saying there wouldn't be penalties against those small employers for violations. So I think they're just not going to worry about it. But we, for now, get an authorization by the leader of your organization, hang on to that, be able to articulate why it would be a problem and have that at the ready if you need it. These are the reasons that you can identify, and it's essentially that the financial obligations exceed the revenue available to the small business due to its small capacity, or that the second one is that the individuals who are seeking leave have specialized knowledge and skills so the business wouldn't be able to run without them, or that you just have too few workers to be able to run the business. So those are the 3 reasons. These are articulated in the Department of Labor's frequently asked questions. So you can look at those further if you're going to invoke that exemption. All right. How does the new law interact with sort of our economic realities that we're facing now? Does it prevent layoffs before the effective date of the law, which would mean today because it goes into effect tomorrow? No, it doesn't prevent them. You can lay people off for business reasons. You can't lay people off to avoid needing to give them this leave. But I don't see that happening. I don't see many employers even contemplating that, because if somebody's eligible for the leave and you can get the tax credit, there may be a cash flow issue for a short period of time, but they're trying to make that a very short period of time. So most employers are willing to give this paid sick leave if somebody's eligible for it. Even after the effective date, if you need to lay people off because of business conditions, so legitimate non-discriminatory reasons that are not connected to their use of paid sick leave or FMLA leave, you can still do that, and the employees will not be eligible for the paid sick leave benefits. If they're laid off before or after the law begins, essentially there's no work for them to need leave from, so they're no longer eligible for these paid leave benefits. They are likely eligible for the unemployment benefits that Jesse talked about at the beginning. Best practices for defensible decisions: be able to identify why you need to lay people off. If you're facing that tough decision, I don't think this is going to be a problem in this current climate. All right, next slide. Does the emergency FMLA cover an employee who is unable to work due to a need to care for an adult child or other family member? So this was a little bit inconsistent within the law originally, and they have clarified that yes, you can take leave to care for an adult child who has a disability if their normal care is no longer available because of the pandemic. It is not available to care for other family members. So it's not available, for example, for elder care or things like that. Does the leave apply if an employee's nanny or other child care provider is unavailable? Yes, it does. It's not just school closures, it's any child care provider, and that's not limited to a daycare center or another facility. Can employees sue? Yes, they can. So the same remedies are available under the emergency FMLA as are available under the existing FMLA. And the paid sick leave uses the Fair Labor Standards Act remedies, both of which come down primarily to back pay, so paying the employee what they should have received if you had followed the law, and then liquidated damages, which means doubling that amount, and attorney's fees. So there are lawsuits and damages potentially from this violations of this law. Are they permanent? No. In the original version of the bill, the paid sick leave law was permanent, but it was limited in the final version through December 31st of 2020, unless it's renewed by a new law. Again, how are we going to pay for this? So the refundable sick leave credit is up to $511 per day, $5,110 in total for the 10 days of paid sick leave for an employee's own health or quarantine. Credit up to $200 per day, $10,000 in the aggregate for the family medical leave for a child who needs health care, who needs daycare or school, or whose school is closed. And the act is you can withhold the credit from at least the quarterly payroll tax returns. And again, IRS issued an initial statement saying you'll be able to withhold it as you go from any payments that you're making on taxes.
Sarah, we do have a question on this in particular. That might be a good time to answer it. It's, can you explain the aggregate limits? Is this the max the employee gets in leave of absence benefits, or is this a tax cap for the employer?
It's both. It's the max that the employee can receive in paid sick leave, and it's the max that an employer can recover through the tax credit. All right. Obviously, these aren't the only laws that come into play. Our existing set of laws and policies still govern. So you want to look at what your normal policies are. And if you need to deviate from those policies, make sure that it's for a legitimate business reason, and ideally issue an amendment to the policy. We're doing a lot of that right now, writing updates to the policy that only apply during this pandemic, during this public health crisis. And then those amendments will sunset, your regular policy will be left in place. Require employees to follow call-in procedures. So that's often one way that we manage abuse, is to make sure that people are communicating. We have to think about doctor's notes. The law allows you to continue to require them. So just as you would for a disability request for accommodation or an FMLA claim or a return to work slip, you are allowed to request those things. The CDC has recommended that employers not request medical documentation so as to avoid overburdening the healthcare system. And practically speaking, it may be a challenge to get doctors to fill these things out if they're just completely overburdened. So you may have to start thinking about alternatives. Sometimes it's using an attestation from the employee or requesting information from the employee and saying, I reserve the right to confirm this with your doctor. But if you can't get doctor's notes, sort of think about drawing reasonable lines there on what you will accept. And again, you can create temporary pandemic policies. The FMLA, the traditional FMLA, still may apply. It provides 12 weeks of unpaid leave. Note that 12 weeks is the same bucket of leave for the emergency leave. So regardless of why somebody's using the FMLA, they have a total of 12 weeks to use. The other that might come into play are an employee's own serious health condition or a family member's serious health condition. COVID-19 might qualify as a serious health condition. Certainly if somebody's hospitalized with complications, it would. If they just have a typical case, from what we're hearing, that may not qualify, just like influenza often doesn't qualify as a serious health condition because you're not seeking medical treatment. There isn't any continuing treatment involved. You just need to rest and wait it out. The ADA may come into play, again, if somebody has complications, and also if somebody has an underlying health condition that may be exacerbated by COVID-19, there may be accommodation obligations there. We're seeing this come up a lot by the people who are saying, I don't want to come into work because I've got diabetes or what have you, an underlying health condition that makes me, that may be aggravated by COVID-19. That should be viewed as an accommodation request, and you look at whether or not you can accommodate, perhaps telework or a leave of absence, provided it doesn't create an undue hardship. Workers' compensation may come into play. I think we're getting further and further away from that being likely. Just as there's more community spread, it's going to be much harder to pinpoint that somebody contracted COVID-19 at work. But if you've got circumstances that are pretty clearly that, it's worth reporting to your carrier. And remember that there's retaliation provisions under all of these laws and the new laws. So you have to avoid treating people differently because they have invoked rights under any of these laws.
And just a quick add-on here. So for some of you, the FMLA benefits are you have to have 50 employees for those to start to apply. So that might, some of you might not have enough employees to meet the threshold for that law to apply. Similarly, the Americans with Disabilities Act has a 15 employee threshold. Even for some of you, that law might not apply, but there is the Wisconsin Fair Employment Act, which has similar disability accommodation requirements, and that applies to anybody with one or more employees. So that's going to be, if the Americans with Disabilities Act requirements don't apply to you, there's probably the state law that does.
All right. Some quick FAQs. Can an employer advance vacation time or PTO to an employee to cover COVID-19 absences? Yes. You can certainly do that. Many employers are, letting people sort of go negative in their accrual. You're not required to, but you're allowed to. Similarly, you can set up a plan to excuse absences related to COVID-19. So say they won't count under your normal attendance procedures. Be a little more lenient there. That's certainly allowed. We talked about this a little bit. Is a COVID-19 diagnosis an FMLA covered serious health condition? It's going to depend on the circumstances. You have to do the analysis if you're covered by the law under the FMLA. It has to be a serious health condition, which generally means more than 3 days of incapacity and seeking treatment by a healthcare provider and having continuing treatment. Is it a disability? Again, it's going to be case by case. An ordinary case of COVID-19 probably is not. However, if there are complications, it may be, or if there's an underlying health condition, that may be a disability.
Okay, so that's our content for today. Just some recommendations for after you leave us. Monitor the latest guidance and be sure that you're staying on top of updates. As I emphasized at the beginning, this is all subject to change quite quickly. Try to communicate regularly with your employees. They have questions regarding how you're going to respond in light of some of these laws. So make sure that they're aware of decisions once you've made them. Be flexible in these circumstances, but also be consistent and not start to treat one group of employees differently than others. And, work with HR and legal to the extent you can to address individual issues, because, the biggest of employers are having questions about how these laws are going to apply. So it's absolutely expected that even if you're a smaller employer, you're going to have some unique situations that require individualized guidance. Again, if you look on our website at the top, you can see the Coronavirus Resource Center that we've set up. This has a long list of blog posts and frequently asked questions. We're continually hosting daily webinars that are complimentary to attend. Some of them you just have to be quick on the draw to register for because they're proving to be really popular. But a lot of these resources are hopefully going to be helpful to you to navigate some of these difficult situations and to keep up on the laws as they are passed. So I do want to try.
Jesse, we've got some good questions in the Q&A that I can start to run through if we've got a few minutes left. Does that make sense?
Yep, that's just where I was going to next.
Perfect. So somebody asked whether the Wisconsin Safer at Home order counts as a government ordered isolation order for the emergency paid sick leave. I spent all of last week fretting about this question, and then the Department of Labor addressed it, and no, it does not. So the stay-at-home, shelter-in-place orders that are being issued across the country do not count as isolation orders. So if an employee is unable to come to work because of one of those orders, they're likely going to be eligible for unemployment compensation, but not the paid sick leave benefit. And then somebody asked if somebody could telework but for their noisy children at home. I think this one said a baby, but perhaps I'm projecting with the noisy children comment. Would they be covered by the FMLA? If they truly can't telework because they have to care for their child, then yes, they would be covered. And I think that is what it contemplates. And we had a lot of discussion in our office about, do you really need to stay home to care for like a 17-year-old who's off of high school? And you probably want to make sure they don't throw like a raging party, but you might be able to telework while they're home, doing their schoolwork. So it's going to be a case-by-case analysis, and you can talk with the employee about whether you and they think that they can really telework. And if not, they'd be entitled to leave under the law. Then a question about intermittent use. And I have to note, this question came in from Andy Gale. I don't know if this is the same Andy Gale, but if Andy Gale, you used to coach skiing, I think you were my ski coach at one point. That would be a fun coincidence if it's the case. But your question is a good one either way. Does the FMLA leave have to be taken continuously, or can it be taken intermittently? And it can be taken intermittently by agreement. So employers don't have to offer it intermittently, but they can, which makes sense for childcare, right? You might switch off with your spouse. If you laid off workers earlier this month due to lack of revenue, but would be willing to bring them back on with the FMLA changes, can you do that? I think that you want to think carefully about which is going to be more in their interest. The unemployment benefits with the $600 addition from the federal government is becoming a pretty rich benefit that competes with the 2/3 pay sick leave. And I would be a little nervous if you don't actually have work for people in bringing them back. I don't think that the IRS is going to get that into the weeds on auditing people about whether they're really eligible. But I think there would be a risk there that if it looks like you're bringing them back only to get that benefit and you don't really have work for them, I think there's a possibility that the IRS could say that you aren't really eligible for the tax credit.
This is probably a good time to acknowledge that we aren't tax lawyers, and so our information today is really limited to employment law issues. So we would recommend that you consult. If you have tax questions, we'd recommend you consult with a tax professional.
Absolutely.
Okay, I can take a couple, Sarah, to give your voice a break if you want. So one question is, will an employer's unemployment rate be frozen, or should we expect to see an increase down the road if and when benefits are paid? We sort of addressed this before. It's a little bit up in the air. Right now, there's not been any indication that the typical tax rate formula is going to stop applying. So for right now, I would say that you can probably expect an increase, but again, it's all subject to be impacted by the boost in federal funds to the state's unemployment coffers, and then also whether the state decides to take any unique action with respect to unemployment tax rate. The next question is, my understanding is that spouses who are employees of sole proprietors are normally excluded from receiving unemployment. Does pandemic unemployment assistance provide any coverage for spousal employees? So whether you're eligible under the typical situation for unemployment benefits in Wisconsin is really determined in large part by whether you your employer was paying into the unemployment tax system while you were employed. So for self-employed individuals, for example, they typically aren't eligible because they hadn't paid taxes into the system, and so they can't draw on those funds. The pandemic unemployment assistance benefits are designed to address people who aren't otherwise eligible for unemployment benefits by making them. And there actually is a provision in state law that provides if the president declares a major disaster for an area, then the state can make typically ineligible people eligible for benefits. While the CARES Act is essentially taking care of that by really, in effect, making the whole country subject to pandemic unemployment assistance. Another question was, how does a self-employed person file for benefits, and would they also be eligible for the $970 per week? How is income calculated for this purpose? So it's a little bit unclear, and it's going to be subject to, I think, the state agreements with the federal government, how the pandemic benefits play out. My reading of it is that and expectation is that self-employed will apply for benefits through the Department of Workforce Development like anybody else does, which right now is available through the website, is what they're strongly encouraging people to do, and that they would be eligible for potentially up to $970 per week. How is income calculated for this purpose? If, for example, if there's partial unemployment, there's a specific formula that applies to individuals. The Department of Workforce Development has a really great plain language explanation of that formula if you sort of just Google the partial unemployment benefits. Is there an estimate of when the $600 boost in unemployment benefits will be seen by recipients in Wisconsin? Again, I hate to sound like a broken record, but that's going to be in part based on how quickly the state enters into an agreement. Thus far, we've seen Governor Evers pretty quick to address these issues, and my understanding is that it's only going to require his authority to enter into the agreement with the federal government. I read an article in the Journal Sentinel today about the Senate Majority Leader was planning on legislation to address the current COVID circumstances to be passed in the next couple of weeks. So I would expect in the next 1 to 2 weeks, we'll have a much clearer answer on this and possibly have some of those boosted unemployment funds being distributed.
One more that I think is worth addressing. I know we're a minute over, so I'll be quick about it, but somebody asked, they're planning to reopen their business after layoffs shortly, and they're going to have problems getting employees to come back. And that is something that I think businesses are starting to think about with these pretty rich unemployment benefits, that in some cases, if you've got people making the minimum wage, and by one calculation, and I can't remember what state it was, it does depend on the state, somebody had calculated that people making up to like $50,000 a year may end up being better off staying on unemployment. I don't think that's the case in Wisconsin. I think our cap is low enough that it's not going to be that big of an impact, but the unemployment benefits are pretty generous. And when you've got, kids out of school and things like that, and other challenges to coming to work, not to mention sort of fears of being out and about right now, I think that is a reality that people may have to face, is it just being a challenge to get people to come to work in this day and age. And so I think thinking about alternatives there, hiring up to make up for that and things like that may have to be part of the strategy.
Okay, thank you everybody for attending. Sorry we didn't quite get to all of the questions. I think some of them that I'm seeing that remain are, we might have covered them with other questions. But our contact information is up there on the screen. If we can be of assistance to you, please contact us. And thanks again for attending today.
Yes, thank you, Jesse and Sarah. As a reminder to all participants, you can sign up for office hours, and a generator team member can handle any questions you may have. They're 20-minute meetings, so feel free to sign up. I believe you received an email from Lauren, so you have the link to sign up there. And we also have our contact information for the resources here today. So thank you all. We do have another webinar tomorrow around the SBA loan process at noon, so please feel free to join then. Thank you.